The official summer protest season hasn't even yet kicked in. Check it out. Protests and riots are usually in the summer. It's a real thing. Lawcracker checked. But the protests have been kicking off left, right, and centre. Protests about COVID laws, protests about feminism, protests about racism, both for and against. And then we've got the government who thinks now is a good time to make laws making it harder to protest. And you know what comes as a result of that bright idea? Protests about laws about protests. So what are these new laws about? Does a responsible government need to modernise our protest laws when everyone with an opinion now seems to be getting on a day saver to London with their megaphone and their placard and telling us they shall not be moved? Or is actually freedom of speech under threat with these new laws? And is it actually Boris's barmy army who've criminally misread the mood of the nation? Brothers and sisters, protesters, officers of the law, stand fast with me because we're laying siege to this bill and we won't stop until we know what's going on. It's law cracking time. Protests, they have been called the lifeblood of a healthy democracy. And it's been said that they're an important freedom that makes life different here from a lot of countries that aren't too much fun to live in. And in fact, our law on human rights says that we have a right to protest. The European Convention on Human Rights says under Article 9, you have freedom of thought. Under Article 10, you have freedom of speech. And under Article 11, you have freedom of assembly and hanging out. And pretty much every country in the world that's open and democratic, not necessarily perfect, but at least moderately free, has similar protections to the right to protest. But those rights can be limited for reasons like public safety, if it's done so proportionately and crucially only where it's necessary. And as far as protests are concerned, a lot of that law limiting protests is held in sections 12 and 14 of the Public Order Act 1986. And the big story at the moment is that some changes to the law are being proposed about when processions and public assemblies or gatherings can be altered by police or even forbidden from taking place in a particular place. Enter the Police, Crime, Sentencing and Courts Bill, which is a 300-page proposed set of laws on everything to do with the justice system. The fact that that bill is 300 pages long is basically a consequence of a government which is catching up on 5 years where it's pretty much done nothing on law and order while it was busy chasing its tail on Brexit. A bit like when you skive school for a week and a half, say you've got glandular fever. It's easy to fake. Just say you're tired. But then have to do 10 homeworks, a geography project, and wash your PE kit all in one night before you go to school to face the music. So what's all the fuss about? Well, in this PCSC bill, there's a clause to be added to Section 12 of the Public Order Act, which will now say that if a procession or assembly has a significant impact on the community, then it can be subject to conditions as to where it takes place, or if it takes place at all. So what's impact? Well, if you think that's a strange word to be using as a reason to think that a protest should be limited, then you may well have a point. Up until now, reasons to limit a protest in Section 12 of the Public Order Act have been limited to situations where A, it may result in serious public disorder, serious damage to property, or serious disruption to the life of the community, or B, the purpose of the persons organising it is the intimidation of others with a view to compelling them not to do an act they have a right to do or to do an act they have a right not to do. In other words, evidence of intent to violence, criminal damage, and that thing's serious disruption, which probably means maybe the transport network or communication systems. But as for intimidation, well, that's a pretty heavy word, isn't it? And as for compelling people to do something they don't want to do, use your imaginations for that, law crackers. That all sounds a little bit like phone booth or speed from the 90s, before Lawcracker was born, but not Speed 2. Because that would be truly shameful. But whichever way you look at it, as protests go, you can kind of see why conditions, if they're proportionate, could be put in place, and it probably might be fairly reasonable and we wouldn't be too angry about it. Hey, we're talking about serious disruption to the life of the community here, danger to residents, etc. But what about this business of now adding the word impact? All those other words, what that man was talking about, what was bad words, and impact is impacts just... It's not a bad word, is it? Well, hang on a minute, Lawcracker, I hear you say. You have long hair, you wear stylish t-shirts. You must be one of those liberal elite types I've been hearing about who are against this bill from the get-go. Maybe the word impact in this bill could mean something quite damaging to the community. Well, although one or two of those statements may hit home a little close for comfort, reading more of the proposed changes about this impact business is actually slightly depressing. Under a new subsection 1 in little brackets, little ab, noise is now something that can decide impact. Excuse me, noise? Yes, significant noise is now a reason to limit protest. Excuse me, miss, I have a question. Isn't it? I thought it was a protest. Isn't it? Noise. Yes, it's a protest where if you now plan to make significant noise, you're at risk of your protest being cancelled or other stuff, or times changed of when it's going to be. Does it even matter? Okay then, but to be fair, let's look at the other side. The government also says in proposed new subsection 2A, the noise generated by persons taking part in a public procession may have a relevant impact on the persons in the vicinity of the procession if it may result in intimidation or harassment. Well, that's not particularly controversial, is it? Lawcracker says intimidation and harassment directed at somebody are not cool. But then we get to the point where the wheels of credibility well and truly do fall off, because we are told then that noise may also have a relevant impact if it may cause serious unease, alarm, or distress. And this is one of two WTF moments in these proposed changes. If the noise a protest makes can make people feel uneasy, then the government can limit that protest. Ouch! And we're back to what the purpose of a protest is. It's literally to make yourself heard, isn't it? That appears here to be restricted. Now, all right then, let's park that. What else does the PCSC bill say about protest? Maybe it doesn't get any worse than that. Maybe this is a bit of an overreach in otherwise fairly decent proposed legislation. Well, we did hear that word disruption was in there, wasn't it? And Lawcracker's take on that, to remind you, was that it probably refers to things like messing with traffic, transport systems, communications, all that type of stuff. Bear in mind that the whole time with all of this, going back to the beginning, all of this stuff has to be compatible with those Article 9, Article 10, Article 11 rights, which guarantee the right to protest unless there's a proportionate reason to limit or prevent it. Now, the phrase serious disruption is nothing new in the Public Order Act. That's the first thing to say. I've given some definitions of what it might be, but two things happen to disruption in the new rules. First of all, our pal noise is back in the mix. Serious disruption can be caused by just being noisy. But the words serious disruption, don't they actually sound like more of a big deal? Lawcracker was seriously disrupted when he found out that D.I. Fleming was no longer part of the anti-corruption unit in television's hit series Line of Duty. And Lawcracker was further seriously disrupted when somebody told him that that bloke from the Go Compare adverts doesn't really sing the Go Compare theme song. But he was very relieved to find out that in fact it was all a terrible misunderstanding, and in fact he does. Phew. Hopefully we have established by now the principle that the phrase serious disruption for most of us, at the very least, means a very big kerfuffle. Not any old nonsense that the government doesn't like and wants to stop because it's a bit annoying or whatever. But actually now under this new proposed legislation, it's not so simple as that. Because under a new subsection 12, this government wants the Home Secretary, this lady, who appears generally to be pretty angry with everybody who she thinks is apparently ruining our country, to be able to define what disruption is in her own special laws that she passes on her own without a vote in Parliament, called statutory instruments. Now, the first thing to say is that statutory instruments aren't something new, although Lawcracker being able to pronounce them is a relatively recent achievement. They're basically secondary laws which help the big laws do their thing. For example, they might decide the date when parts of an act formally become law. Kind of like Robin, if you're Batman. Or in fact, probably a better example would be Alfred, if you're Batman. And if you're an Act of Parliament. But this stuff is not Alfred. The Home Secretary deciding what makes a protest disruptive in law, this is a major league decision. And doing it off the cuff, going over Parliament's head as you feel like it, for anybody to have that individual power is probably a bit worrying. Now, to be fair, this lady Cressida Dick, who is Britain's most senior police officer, says the ability for the Home Secretary to decide what disruption is important for her officers so they don't get confused. But aside from that, is there actually a point that when people's lives are made inconvenient, think Extinction Rebellion folks, people supergluing themselves to things in the city, stopping traffic from going, etc., 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 shouldn't people decide if they're going to protest, try and do it in a more considerate way, like these fine gentlemen protesting against something? The point of protest is actually that it is uncomfortable, it's inherently disruptive, it gets some kind of reaction. Yes, we've got elections in a democracy, but most people who thought about these things actually consider that protests are a kind of extra important democratic exercise because they're a show of unhappiness with the status quo outside the system of elections, and they've been a major contributor to some of society's most important changes. The vote for women, anyone? Does anyone think that that was a particularly good idea? Perhaps some of you don't agree. Lawcracker thinks it was a splendid idea. And here's the thing. When people have a sense that democracy is failing, or at least when people feel disconnected from what it's doing for them, protest becomes their only voice. It's a way of allowing those voices to be heard and for people to be noticed. Now, the theory goes that we only get to vote every so often. And, still sometimes when we do, the system doesn't really work perfectly and politicians let us down. And when someone lets you down, what do? You go to see them. Unless they let you down by standing you up for your first date outside Knutsford Studio Cinema when you're 13 and it scars you for life. But obviously you go to see the film anyway, because it's 1993 and it's Super Mario Brothers the movie. But the point is this, we only get to vote so often, and sometimes our politicians, they don't do what they said they'd do, and displeasure needs to be expressed. And we do it by going to the very place of power where decisions are made. The suffragettes, who fought for the vote for women, protest sometimes with violence. And they even took 3 mass protests as far as the Parliament building. Those protests would be banned now under existing legislation because you can't go up to the Parliament building in a group to protest. But in this bill, the government now wants to extend that no-go zone around Parliament even further. Now, to be fair, the head of the Met Police, Cressida Dick, we heard about before, says that in recent years we've seen a significant change in protest tactics which have led to disproportionate amounts of disruption. And the current legislation the police use to manage protests was enacted over 30 years ago. And she also says that the police need help if they're going to safely and effectively manage the highly disruptive protests we see today. So she's basically saying these were new methods. Commuter trains were late, MPs were late to get to their fancy second homes. Disgracefully, people's tea became cold. She's also repeated this idea in many places that the Public Order Act is somehow ancient legislation that has somehow gone stale and is outdated, and that's why she says new laws are needed. Is that fair though? Britain has a history of protest and rebellion, in fact, going back 1,000 years. An Extinction Rebellion's protest wasn't on some completely different planet to the Trump protests a couple of years ago or the Iraq War protests about 15 years ago, as far as the scale of it is concerned, or indeed a load of noblemen in the Middle Ages with soldiers and horses and swords and gubbins going to threaten King John. To say that the Public Order Act, because it was passed in 1986, is somehow old in legal terms, from a lawyer's point of view, is nonsense. In fact, all the evidence is that good law lasts. Our law on people having a right to a lawyer and to be properly treated by police in the police station goes back to the Police and Criminal Evidence Act 1984. Our law on violence comes from the Offences offences against the Person Act of 1861. The clause of Magna Carta, which guarantees the right to a trial by jury of your peers, is still in force after 724 years. So saying that the Public Order Act 1986 is out of date, it's a bit silly. As the saying goes, age does not matter unless you're a cheese. Cressida Dick also doesn't really explain why it is that these people need to go to prison under the new legislation when previously they would have only been arrested and fined if they were in attendance or went back to the scene of a protest. So is there something else going on? Is this a government that is so afraid of dissent and protest, which is admittedly inconvenient, sometimes unreasonable? Are they just trying to fob us off by saying, no, this protest is different. The rules of the game have changed. This is on another level. Another level is this. Emily Davison. Now that's a name you might not know, but I bet you've heard what she did. And it's the single most vivid image in our nation's memory in women's fight for the right to vote. Because in 1913, at the Epsom Derby horse race, she made her way calmly out from the stands, directly into the path of the leading horses as they raced, and tried to grab the reins of the king's horse before it trampled her to death, which came 4 long days later. Protest is actually an inherently muddy and bloody affair. Being on the right side of history can be dangerous, it can be unpopular, and you can kind of break a few laws on the way. It's certainly both disruptive and uneasy. Thomas Jefferson once wrote something that you may well have heard, but like most people, you may have thought you knew what it was about, but didn't know that the context was a little different. He said, "The tree of liberty must be refreshed from time to time with the blood of patriots and tyrants." But this wasn't in the battle with the British Crown. He was actually talking about a violent attempt to overthrow the state government in Massachusetts by Americans. He said, "What country can preserve its liberties if their rulers aren't warned from time to time that their people preserve the spirit of resistance? Let them take arms. The remedy is to set them right as to facts, pardon them, and to pacify them." Well, Lawcracker's verdict is whatever changes we make to our right to protest, we should probably look at doing it very, very carefully and always try to remember and realise that protests, however annoying they are, however inconvenient they are, and especially however much we disagree with them, are a really important part of our democracy's health. This was the Lawcracker. Tell me what you think. Do these changes matter? Are protests just a thing for troublesome folk who should be busy working and helping the government instead of working against it? Or are they heroes who change society for the better? If you don't like this episode, you may discreetly protest in the comments. Guys, I really want to thank everybody who has liked, shared, and everybody who has subscribed using a button, which I always forget on what side it is, in the past few weeks, and push the bell. You could be like them if you did that. I have to say also, we got a really nice write-up in the online legal magazine, Legal Cheek, and some very funny comments. NXO, cool name, had this to say: "A welcome break from all of the insufferable influencers with their potted plants, highlighters, and MacBooks." Well, that made Lawcracker chuckle rather. I do have a MacBook. Also, let's not forget Misty Gish, cool name, who said, "And yet you would not want this to represent you before a court." Well, wonderful to see that all of the general public regards Misty's comments to be a little bit harsh. Exhibit A, 2, count them, dislikes. The people have spoken. It would be awesome if we could get to 200 subscribers on the channel, bearing in mind that it was kind of in double figures just a few weeks ago. Please reach out and tell me what you think, what you'd like to see on future Lawcrackers. Thank you. Disclaimer, this is not legal advice. No letting the blood of patriots today.